All right, welcome back to part 2 of chapter 9. So let's go ahead and just jump right into the second half of our lecture. So we're going to start off with, and if you're following along, we're on page 268, but we're going to look at ethical issues for prosecutors now. So we talked about defense attorneys, etc. Now let's look at prosecutors. So prosecutors do not serve an individual client. Rather, their client is the system, right, or society itself, and their mission is justice. Now, on the other hand, prosecutors, like anybody else, right, they want to win, and so they can be influenced by just that particular desire. Now, as the second line of decision makers in the system, prosecutors really do have an extremely broad power or powers of discretion. And the prosecutor basically acts like kind of like a strainer, if you will. That's probably the best way we can say it. He or she collects some cases for formal prosecution, right, while eliminating a great deal of others. Because as I mentioned earlier, prosecuting every case is really, it's impossible to do that. So they're weeding out the cases that can be disposed easy or sent somewhere else, etc. And they're taking on those, I guess, more important, higher level cases, if you will, that really require formal prosecution. So hopefully that kind of makes sense. Remember, resources are limited, and sometimes evidence is weak, making it unlikely to win. The early disposition or diversion of some of these cases really will help save a lot of money in the long run, right? So, we know that the prosecutor must seek justice, not merely a conviction. Now, towards this end, prosecutors must share evidence, exercise restraint in the use of their power, represent the public interest, and give the accused the benefit of reasonable doubt. Now, with that being said, there are some factors that prosecutors can use to decide whether and what to charge. Okay, and here's some of the following factors. Now, they're on page 269 in your book, but it could be the strength of the case. Okay, the prosecutor's doubt that the accused is guilty. Extent or absence of harm caused by the crime, meaning like somebody stole a potted plant. The level of harm is less than someone that embezzled $10 million. And I'm not taking anything away from the victim, but this would be the extent or absence of harm. Impact on public welfare, the background of the offender, punishment or consequences are disproportionate, that would basically mean whether the authorized or likely punishment or collateral consequences are disproportionate in relation to the particular offense, etc. The views and the motives of the victim or the complaining party, if you will, maybe improper conduct by law enforcement, unwarranted disparate treatment of similarly situated persons, if you will, a potential impact on a third party, influence of cultural, ethnic, socioeconomic biases, changes in law or policy, limited prosecutorial resources, prosecution maybe by another jurisdiction, that could be there, civil, regulatory, administrative, or other private remedies. So a lot of different factors, right, that the prosecutor uses whether to, prosecute a case or not. So, again, despite these ideals of prosecutorial duty, an unstated influence over basically prosecutorial discretion is that prosecutors want and must win to be considered successful. And a decision to prosecute, is influenced by the factors we talked about, right? There's a lot of different factors, but it could also be based on political and public pressures. So some different things. So the prosecutor really must seek justice, not convictions, even though they want to win. They have discretion to charge or not to charge defendants, one of the most important decisions in that criminal justice process. Just like with law enforcement, the discretion to arrest or not to arrest, especially a juvenile, is a huge implication. So the decision to charge, we have to kind of think about that. Could it be influenced by politics? Is it influenced by sensitive capital cases? Could it even be influenced by law enforcement pressuring the DA's office, the prosecutor's office, to file a particular case? So these are other things that affect that overall decision to charge. Now, one of the big things that tends to kind of come up in some cases, okay, would be what they call the duty to disclose. Because the obligation to disclose what they call exculpatory evidence has been established in several different cases. And let me jump ahead. Okay, I have all three, okay? And I'm not going to read each case. I put the link in where you can click there and you can look at the actual case. But the first, the big case is what they call Brady versus Maryland. And Brady motions are basically standard pretrial motions requesting that all exculpatory, and that means evidence favorable to the defense, okay, held by the prosecution, be turned over to the defense. So basically what it says is if the prosecution has evidence that might show that the defendant is not guilty, they have to turn it over. Any evidence that's favorable to the defendant, that's held by the prosecution, must be turned over to the defense. And you could see the ethical dilemma maybe by the prosecution that they may not want to hand stuff over, right? So there's a little bit of a fine line there. Another case is Giglio versus United States in 1972. And this case revolved around the failure to inform the jury that a witness has been promised not to be prosecuted in exchange for their testimony. Okay, so a lot of times if there's more than one defendant might testify against another, and the prosecuting office might give them a deal, if you will, to testify. That has to be brought out, okay, that they've been given this particular deal, if you will, in order to give their testimony. All right. So failure to fulfill the duty to presenting all material evidence to the jury. The jury needs to know that there was a deal made. Okay, so that's that case. So that's Giglio versus United States. And then finally, and there's a couple of other ones too that are listed in your textbook. United States versus Eggers, 1976. This is a case where the prosecutor did not disclose that the defendant's victim had an extensive criminal record. And then United States versus Bagley in 1985, this is where the government did not disclose any type of impeachment evidence, meaning evidence that would be contrary to a witness's testimony, which could basically impeach them or show that they're not telling the truth. So important cases, and the duty to disclose is really a big deal. And Brady really is the number one case when it comes to all of that. So what about conflicts of interest then? So the prosecutor's professional judgment or obligation should not be affected by the prosecutor's other interests or relationships. And there are some different problems when it comes to, let's say, part-time attorneys and things like that. So problems related to part-time prosecutors duty to their private practice overrides their duty to handle regular cases. And some other problems related to a prosecutor's political aspirations, meaning they might use this as a stepping stone. So what we're trying to kind of say here is that, again, the prosecutor's judgment or obligation can't be affected based on other interests or relationships. And we do find some conflicts when you have part-time prosecutors, if you will, that might still have a private practice, because they're going to make a lot more money, right, in their private practice. So that could be a conflict of interest. And then along with that could be a prosecutor's political aspiration, meaning that they're going to use this particular case as a stepping stone. So about 15% of chief prosecutors are part-time, compared to about half in early 1990. And obviously, like I said, this poses the possibility of a conflict of interest. It may happen that a part-time prosecutor, again, has a private practice, and there may be situations where the duty to the private practice kind of runs counter to the duty of, prosecuting a possible suspect, etc. Another potential conflict, could be when officers are accused of wrongdoing. And I can see a typo right here, so it's not could, it's could. Because so few officers face charges for, shootings or use of force, the argument could be that the local prosecutor is unable to use their discretion fairly. Perception is everything in a lot of people's eyes. So the perception is that the prosecutors cannot be trusted to basically police themselves, right? So again, a lot of critics that are out there, and there's not many, but there are some, basically maintain that, police departments can't police themselves. And a similar criticism could be made of a prosecutor's office, where they can't be trusted to, let's say, prosecute officers, since it conflicts with their working relationship. So these are just a couple of other possible conflicts that could happen out there. Other things to consider would be things like asset forfeiture. And we're going to talk a little bit just briefly about asset forfeiture. So the financial resources that can be seized with minimal due process in asset forfeiture may also pose a conflict of interest for prosecutors. And although police are most often associated with asset forfeiture, they must depend on the prosecutor to take the legal steps of actually seizing the property. So there are several problematic issues with civil asset forfeiture. Okay, the exclusionary rule doesn't apply to civil forfeiture proceedings. So some allege that police are now pursuing assets instead of criminals, because they don't have to worry about the evidence being suppressed. So what we're saying here, or what they're saying, is that if you illegally search someone and you arrest an individual, that evidence could be thrown out, right, via the exclusionary rule. That's the name exclusionary. Okay, it can't be used because it was seized illegally. However, assets, okay, that does not fall under the exclusionary rule. It doesn't apply to civil forfeiture. Therefore, even if these things are obtained in violation of the Fourth Amendment, etc., they can still be seized, etc. Okay? In a civil forfeiture proceeding, the defendant does not have the right to legal aid. So if they can't hire an attorney, then kind of like too bad. So that could be troubling. One troubling aspect of civil forfeiture is that third parties are often the most hurt by the loss. So for example, the spouse or the parents of a suspected drug dealer may lose their home, bank accounts, etc. So it's a third party that's being affected here. So critics say that there really is something fundamentally wrong in government agents receiving profits from their use of their power. Now, keep in mind, if you know about asset forfeiture, it basically does target drug dealers, etc., and financial crimes and things like that. And the officers don't keep the money. They don't keep a percentage of the money. It goes to basically to the county and then to the state. And then the department that made the arrest or recovered the assets, etc., gets a portion of that to be used only under certain circumstances. And we're not going to go through all of the circumstances, but typically it's for drug abuse, certain drug programs, rehabilitation, specialty equipment, things relating to drugs, okay, etc. So you can't just, you're not going to throw a party with asset forfeiture stuff. But some people say, and rightfully so sometimes, that there could be some misuse of the asset forfeiture system, okay? Okay, so now we're going to move on to plea bargaining, and this is a really kind of a big deal because we know that, as we discussed earlier, okay, there are some ethical concerns over the practice of plea bargaining, okay? Now, there are some good reasons for plea bargaining as well. So, if the goals of the system are crime control or bureaucratic efficiency, then plea bargaining really does make sense, okay? It reduces cases, etc. Now, if the goals of the system is to protect individual rights, then maybe plea bargaining might be harder to justify. And the question I have at the bottom there is, can someone be pressured into, taking a plea? And the answer to that is yes, and we'll talk about that, right? Now, arguments given in defense, of plea bargaining include heavy caseloads, limited resources, legislative overcriminalization, individualized justice, and legal problems of cases, etc. And plea bargaining continues to be prevalent across the United States. Felony defendants are 20 times more likely to plead than to go to trial. And it's been easily shown that over 90% of cases plead out. Okay? So only that small percentage actually end up going to trial. And even if the practice of plea bargaining can be justified as an ethical way to reduce the number of cases going to trial, there are practices that prosecutors sometimes use within that plea bargaining umbrella that are questionable. And sometimes, they're warned actually against doing some of this. So, specifically, prosecutors are not supposed to overcharge, that is, charge at a higher degree of severity or press more charges than could possibly be sustained by the evidence, so they can basically bargain the case down. Does that kind of make sense a little bit? Prosecutors, they're not supposed to, should not mislead defense attorneys by inflating the amount of evidence or the kind of evidence they have before or during the plea process. Also, prosecutors should not engage in false promises, fraud, misrepresentation of conditions, deals without the benefit of counsel, package deals, or threats during plea bargaining. Yet these tactics have been known to basically happen. So, critics contend that prosecutors really do hold all of the cards, if you will, in plea bargaining. And think about it this way. In my face-to-face classes for criminal law, I give a case study of basically a sexual assault case where it's so vague that both the prosecution and the defense kind of don't have a case. But the case, the high, if you were convicted in this case, would be 10 years, or the low could be that you could be acquitted. So it's kind of like a roll of the dice, right? So if you're arrested on, let's say, a sexual assault case, and you could get 10 years in prison, but your attorney comes to you and goes, hey, they're willing to give you a plea of 2 years. So you're going to roll the dice. If you go to trial and you lose, you get 10. But if you take the plea, you get 2. And with good time, you might get out in 1. So, but what if you really didn't do it? Now, I'm not saying that happens every time, but you can see how you could be pressured, right, into taking a plea because you're afraid that if you roll the dice, that you're going to get the snake eyes and you're going to get the 10 years. So that's the issue that we talk about. And in my other class, we kind of call that the 50-50, okay? So another discussion when we talk about plea bargaining is whether the prosecution should have to share exculpatory evidence. We talked about that. These are facts that support innocence, right? With the defense before or during a plea bargain. So you can really see that gray area there. What if I'm a prosecutor? I have some information that might help the defendant, but I'm going to talk about the plea bargain first, and I'm not going to tell the defense attorney about it. So, do you think that happens? So that's important, and that's a gray area. This is an ethical issue. Now, because of federal mandatory minimum laws and enhancements, federal prosecutors have immense power to basically, persuade defendants. And U.S. attorneys and some state prosecutors routinely require that the defendant basically waive their Brady rights as part of a plea agreement, meaning that, hey, it doesn't really matter whether we have exculpatory evidence or not. You're going to waive that if you want to take the plea. So, is that really fair? And some say yes, and some say no. So these are ethical dilemmas, right? And I hope you can really see some of these now. Now, prosecutors' ethical issues with plea bargaining revolve around what is the right amount of punishment to offer. Defense attorneys' ethical issues include the extent to which they'll try to, basically convince individuals to plead, if they swear that they're innocent. And judges have ethical issues as well, in that they do not have to accept a plea in a case where they do not believe the evidence is sufficient to uphold that verdict. So everybody here kind of gets a piece of the pie, right? So there are some criticisms here. And what about the media? Okay, everyone's favorite thing, right? And I kind of meant that jokingly. So the media can be your friend or your enemy. And some cases are said to have been tried in the media, with both defense and prosecuting attorneys staging, media shows, media releases, etc. Think about those high-profile cases. One famous one that kind of comes to mind would be the Sam Shepard case. That was the case that's based on the movie The Fugitive, or The Fugitive is based on that case. And the other case is the AJ Simpson trial, another media kind of debacle, if you will, even though there were a lot of issues with those particular cases. So typically no out-of-court statements should be given that would materially prejudice a proceeding at trial. Statements regarding the general nature of the charge and information, that is public record, are permissible, but you shouldn't basically be putting out too much information to where you're going to jeopardize the trial. But we know that sometimes that still happens with the media. And then finally, we're going to finish up and we're going to talk about experts and informants. So the use of expert witnesses has risen in years. And psychiatrists often testify to the mental competency or legal insanity of an accused, and criminologists and other social scientists may be asked to testify on victimization or other similar factors. And there are lots of other experts, you guys. There's experts for gangs, which I have testified as an expert for drugs, which I have testified as an expert for firearms. And you were waiting for me to say it, but I'm not an expert in that. But anyway, and both sides, right, the prosecution and the defense, are going to use expert witnesses. Now, expert testimony is allowed as evidence in trials when it is based on sound science. Okay, so we do have to kind of understand that. And the U.S. Supreme Court has defined a standard as to when scientific evidence can be admitted at trial. And specifically, this particular test is called the Daubert standard. And it includes the idea that the judge is the gatekeeper. They're the person. They're the trier of law, or the gatekeeper, to make the determination of relevance and reliability. And the expert can only testify to the scientific knowledge of the facts at hand, not a bunch of other stuff. So hopefully that kind of makes sense. Because what comes with this is something called the halo effect. And this is a phenomenon in which a person with expertise or status in one area is kind of also given basically difference or carte blanche in all areas. Well, he's an expert there, so he's probably an expert here. But that's not what the evidence code allows. They can only be experts based on the information at hand. We go back here. Scientific knowledge of the facts at hand. Okay? And a benefit from the halo effect is when their expertise in one area results in their receiving basically the okay to testify about things in other areas. And you even lose credibility after gaining a reputation as kind of a hired gun. And they do have certain basic experts that all they do is testify for the prosecution, or all they do is testify for the defense. And it's always about guns, or it's always about injuries, or it's always about this. And they only work for one side. That's what they call kind of a hired gun, because they always appear on one side of an issue and they only talk about one thing. And that, again, that's a hired gun. But both sides use these particular things. And then popular TV programs suggest that scientific methods are infallible, meaning that they don't make mistakes. The CSI effect is basically an exaggerated portrayal of forensic science on, crime television such as CSI. Kind of unrealistic expectations. And it influences the public perception that we can do all this stuff that they can do on TV, and we can do it all in like 10 minutes, or within that 60-minute TV program, or 30 minutes, or whatever. So again, there's a lot of things we have to consider when we talk about experts. A couple of quick definitions in other areas. Criminalistics, even when mismanagement, shoddy practices, and untrained staff aren't the issue, many areas of the science of criminalistics seem to be, to some, not to all, more than art than science. I can tell you that criminalistics, a lot of areas of criminalistics are solid foundations, DNA, blood evidence, fingerprint evidence, but there are some that receive some criticism. But what is criminalistics? Well, this is the profession involved in the application of science to recognize, identify, and evaluate physical evidence in court proceedings. And actually, this right here is wrong. And I'm going to fix this right in front of you right here. I rarely do this, but because it's wrong, I want you to know what the right class is. So it's AJ507. And it's Introduction to Criminalistics. So it's a great class. It's in a lab. It's on the Menifee Valley campus. But let's keep going. Okay, so again, a lot of people view criminalistics as solid science, but there are some that don't. And we just have to kind of understand that. That's why both sides bring in experts. I mean, an example could be sleepwalking. Some people believe it's true, some people don't believe it. They'll bring in an expert on each side to determine whether somebody could actually sleepwalk and, let's say, commit a homicide or something. Okay, but serious questions do arise over laboratory management practices, the veracity of the technician's testimony, and the nature of the sciences involved. And here's some areas that sometimes have questions. And I'm not going to go into detail. I'll let you look at those. But they start on about page 280. Hair analysis could be one. Arson investigation would be another. Ballistic testing, sometimes DNA testing, sometimes fingerprint analysis, sometimes bite mark comparison, scent identification, or even some other different types of forensic evidence. All of these are basically the reasons that typically, one side or the other will bring in an expert to basically dispute or draw basically some doubt, if you will, on the expert's testimony. But expert testimony is held in very high regard. Okay, so that's, but there you go. Here's just a couple of pictures that you can kind of look at, and we talk about different things, whether it's fingerprint coding, whether you're matching a fingerprint, whether you're dusting prints, whether you're doing hair analysis or fibers. All of these are different things that, will have to be brought to a lab, to a technician to be processed, etc. And an expert more than likely will testify about it. DNA, this is actually from a DNA class that we did on the Menifee campus. It's actually pretty cool, right? So we process DNA. Even tire tread analysis or footprints or casting. Again, just to give you an idea of some different things. We talked about bite marks. So there's just so much out there. And we utilize a lot of this. We talked about bullet comparison, whether striations, and on the left you can see this is 100% match, and on the right you can see it's not. But they'll bring in, the defense might bring in someone to come up with a different theory, etc. So all of this different stuff. Okay, so then what about this zealous prosecution? We talked about zealous defense. So now let's kind of, talk about zealous prosecution. So the prosecution in preparing a case is putting together like a puzzle. And each fact or bit of evidence is a piece of that particular puzzle. And the problem is that this type of evidence may be exculpatory, meaning that it needs to be turned over to the defense, right? We talked about that. And the prosecutor sometimes engages in tactics such as using witnesses with less credible reasons for testifying, preparing witnesses, and shopping for experts. But the defense does the same thing. So again, it's an ethical issue on both sides. And tactics such as using witnesses with less than credible reasons for testifying, preparing witnesses both, appearance and testimony, and shopping for experts are prosecutorial tools as well as defense tools, like I said, because everybody wants to win. So, we talk about these. You may have somebody testify, and the credible reason could be because they're an informant and they want to work off a case, so they want to testify. That's a credible, that's an issue, right? Preparing a witness, meaning ahead of time asking them questions that you think the defense is going to bring up and helping them kind of rehearse, if you will. Shopping for experts, finding that expert that fits in the niche in your particular case. These are both tools for prosecution and the defense. And they could rise to the level of ethical issues. Because, hey, prosecutors want to win, right? Just like the defense wants to get their client off. And there are very few checks or monitors on their behavior. And this term that we've learned in other chapters called noble cause corruption occurs when the prosecutors break the rules because they want to win, right? The end justifies the means. It's the noble cause. This guy's a criminal. Let's send him to prison. And I'm going to cut a few corners when I'm doing it. Maybe I'm not going to, really tell the defense everything they need to know. Maybe I have a little bit of exculpatory evidence and I'm not going to give it up, so this person pleads guilty. Zealous prosecution. And again, I talked a little bit about informants. Keep in mind, jailhouse informants, they testify that, a defendant confessed to them or said something that was incriminating. And often, the pay, if you will, for this testimony is a reduction in their sentence or charges. But, it could be reduced sentencing or being sent to a particular prison or any other thing of value to that particular informant. It could even be money. It could be a paid informant. That could be a reason for testimony. Now, it doesn't mean that every informant's not good, but these are all ethical issues. And research shows that even though jailhouse informant testimony is highly questionable, it is highly effective. So that's, kind of interesting for us to know. And perhaps, the best known symbol of justice here is the judge that wears that black robe. They're expected to be, impartial, knowledgeable, and, authoritative. Judges, they're human. Judicial decision-making seems to have become, increasingly political in some different realms. And one of the most commonly heard criticisms of judges is that they're not objective. And if you look at objective here, look at the synonyms: impartial, unbiased, unprejudiced, nonpartisan. So subjective, right? So if a judge has some interest in the case, financial, social, emotional, then their decision making can and really should be questioned. And so what can they do? Well, recusal, which means removing yourself from the case, is necessary when a judge has a financial interest in the case, but also when disability, bias, or relationship to the parties might influence the judgment or give the appearance of impropriety. Now, under federal rules, judges must recuse themselves even if there is no bias, but a reasonable observer might question the impartiality of a judge. Now, judges make that determination themselves when a party files a recusal motion. So if the defense feels that the judge needs to recuse themselves, they file a motion. And judges can ethically only recuse themselves for just cause, not just because of any other reason, like the cases. It's a nightmare case. It's a political case. I don't want to deal with politics, so I'm going to recuse myself. You can't do that. It needs to be for just cause, kind of like what we talked about earlier. Now, judges are kind of like the umpire in an athletic contest. They apply the rules and interpret them. And although rules of law are established in rules of criminal procedure and case law, there is still a great deal of discretion in the interpretation of a rule. What is reasonable? What is probative? Meaning proving or demonstrating something, and so on. The judge decides that. And a judge assesses the legality of evidence and makes rulings on various objections by prosecution and the defense. So again, a lot of interpretation of the rules and the laws. And again, one of the clearest examples of that should be judicial discretion is the application of the exclusionary rule, which basically states that when evidence has been obtained illegally, it must be excluded from trial. So take a look at the Fourth Amendment, and also look at the fruit of the poisonous tree. Here it is right here. So that kind of goes along with the exclusionary rule. So the fruit of the poisonous tree is kind of a legal metaphor used to describe evidence that is obtained illegally. So the logic of this terminology is that the source, the tree of the evidence, or evidence, itself is tainted, then anything else gained, being the fruit, is tainted. So an example would be if I illegally search you and I find something a map to a place where you have drugs and money and guns and all kinds of stuff, but I found that illegally, and then I go to that place and I find all that stuff, then that's going to be thrown out as well, because I obtained the first bit of evidence that got me there illegally. Does that make sense? So whatever, gets you there, so that's the fruit. So hopefully that kind of makes sense. And there's a little video for the fruit of the poisonous tree. All right, and then finally sentencing, again, raises unique ethical issues. Is there a single acceptable punishment for a certain type of offense or an offender? Does justice depend on community opinion of the crime, the criminal, and the proposed punishment? Sentencing inconsistencies occur between individual judges in the same community, and controversy in recent court decisions regarding sentencing guidelines illustrates the importance of the judicial role in preserving due process. So are people that are involved in similar cases, similar crimes, are they being sentenced similarly or not? And that could be a real big thing, right? Okay, so we're just about right at the 41-minute mark, which is right about where we want to be. So that's good. And let me kind of get us back up here to the top. All right, so that's going to conclude our two-part lecture for Chapter 9, dealing with discretion and dilemmas in the legal profession.